can go ahead and get started. I'm Tiara Pitts, your Director of Fair Housing. This webinar is a part of our efforts to educate you guys on fair housing, not just in April, but throughout the year, and doing partnerships with companies like Pet Screening and Victoria is a way that we're going to be able to provide that information for you guys. And now introducing our guest, Victoria Coward is a multifamily industry member with extensive experience in management and oversight for multifamily housing communities, mobile home communities, and HOAs. She's a property management instructor who's obtained her degree in management of human resources and then her industry CBM designation. She's passionate about education and simplification and creating understanding and ease for industry members and consumers. Victoria was also a speaker at our recent virtual Fair Housing Conference, which a lot of you guys probably saw her there. And I was really appreciative that she reached out to me and that we could make that happen. And also this today for a longer version that can really get all of your questions answered and make it more interactive. So throughout this, I'll be moderating. Please feel free to put questions in the chat, and at appropriate time, I'll go ahead and ask Victoria to answer that for you guys. We've also provided you with a workbook that we would love if you could follow along with that. And also Sharon has posted it in the chat if you didn't receive that link previously. And without further ado, thank you so much for joining us today, Victoria, and I'll turn it over to you.
Thank you, Tiara. I appreciate you very much. All right. Hi, everybody. I'm Victoria Coward, and I'm super pleased to be here with you. As you heard Tiara say, I come from the property management industry. What I'd like to also share, though, is down here in Charleston, for 7 years, I taught for the Charleston Trident Association of Realtors at night, and I taught half of the property management licensing class with my teaching partner, Judy Wolk. Many folks around the state know Judy's name, and it was an honor to teach with her and to teach for the Association of Realtors. I brought at that time my experience as a multifamily operator, and I love what we all do in the property management side of real estate. So I ended up loving education, both receiving and facilitating, loving legislation as well. And this kind of is the combination of the both. For the National Apartment Association last year, I was their legislative chair. So you know I really love this stuff, and teaching from 6 o'clock at night till 10 o'clock at night for the Association of Realtors meant that I was totally dedicated to the education side. So it's an honor to be here with you all today. This title on this session is You Bet Your Assets, and I want to tell you why I named it that, so everyone's clicking and I've got your attention. If you didn't know this before, I want to make it clear. If you receive a HUD complaint because of your handling of a fair housing accommodation request for the disabled, for an assistance animal, if you receive a complaint for that, and that complaint is either not conciliated or not resolved, and a HUD lawsuit ensues, your name personally, if you interacted with that client, applicant, prospect, your name will be on that lawsuit. And you're not only betting your professional asset, the property that you're renting, you're also betting your own personal assets. If you are involved in that lawsuit, it could involve your own home. So you are betting your assets on your understanding of this topic. And I don't want you to bet. If you're going to have to bet, I want it to be a safe bet. I want it to be something that you're very comfortable with. And to that point, I also want it to be something that you retain. So let's hit retention for just a second, and then we'll kick this into gear. When you're attending sessions like this, the one that you watched, the brief version of this, you probably felt it was pretty simple, pretty straightforward. You understood it, felt good about it. You have that with a lot of sessions you attend, but when you try to recall them weeks or months later, 80% of that is gone and only 20% of it remains. So that's that retention conundrum. And I've tried to address that by asking you to focus really hard on this session with me today, looking at the slides, listening to me, and especially writing your notes out. There's something really particularly good about writing notes, and that's why in your workbook, we have all of the slides and space underneath each one or beside each one for you to take notes. So if you're looking and you're listening and you're writing, your retention will improve. And if you're asking questions, it literally doubles your retention. So the minute you have a question, don't wait. Don't worry whether or not I'll cover it later. Immediately put it into the Q&A for us, okay? Don't use the chat for that. Put it into Q&A, and that will help Tiara at the end to be able to move through everything. So immediately ask your questions, right? And then we'll get you from losing 80, retaining 20, to retaining 80 and losing no more than 20, okay? Let's get this going. First, I want to say I'm not the attorney. I am an expert in this topic, and I love what we do, and I've studied this extensively, and I've put all this past our general counsel, or our chief legal counsel here at Pet Screening. But if there's anything in this presentation that gives you cause for pause, please take note of that and go over that within your company, within your structure, with your risk management or attorneys. Now, you know the formula. Let's tell us what we're going to tell us, and then tell us, and then tell us what we told us, right? So here's your presentation outline, what we're going to cover today, and this is in your workbook. The human statistics, why we're seeing so much of this. A little bit of the fair housing background, just 2 slides on that for folks who are newer to the industry. Then we're going to go into the assistance animal accommodations, the who, the what, the HUD part. Then we're going to talk about the request journey, the pathways components, the process, and the outcomes. And then I'll share a little bit about pet screening and about our free services that takes all of this work we're talking about today off your hands. But meanwhile, while you've got it, I want you to feel confident about it and graceful. All right, let's go into the human and animal statistics. Why are we seeing so much of this in our world? We'll take a look at these numbers, folks. This is some of the disability information that I've found in my research as to what's going on out there. You've got 61 million adults living with the disabilities on this screen, and there are many disabilities missing from these numbers. So the number's actually far higher. So you're talking 25, 26% of the folks you're encountering living with a disability and then some, again, because of the disabilities that are missing. With these numbers, and knowing 25, 26% of adults are living with a disability or more, if you have a 250 unit portfolio, at least 65 in your portfolio, at least 65 of your homes are going to have a disabled individual living in them. And that's an important number. Pre-pandemic, 1 in 10 adults would say that they were suffering from a mental illness. 1 in 10. Now that number, as of 2021, 4 in 10. 4 in 10 from 1 in 10 went from 10% to 40% from pre-pandemic to 2021, not quite post-pandemic, right? And recently, the National Apartment Association did a survey of its members, and its respondents said in the last year, 40% of them took time off from their work due to not feeling emotionally well enough to perform their jobs. And 12% of those took a week or more. 42% of the respondents said in the month prior that mental and emotional health had interfered with their personal lives. So there's a lot of mental, emotional, and physical disabilities in our country. And that's giving rise to these assistance animal accommodation requests. On the animal side, we are a pet passionate society. We have gone way beyond pet friendly. We are now pet passionate, if not pet wild. 70% of the homes in this country have a pet or animal. Good news is though, 91% of those are still straightforward household pets. 9% of them are assistance animals. But why are we seeing quite so much of this at this time? Again, that quote at the bottom says it all. So many folks too, think about this, are working from home who weren't working from home before. And what does that give them? The opportunity to raise a pet that they've never had before because they're home, not feeling like they can't tend to a new puppy, right? So think about that. 70% of the homes in the country have pets or animals. And just by contrast, to kind of put this in perspective, how many homes in the country, what percentage of homes in the country have children? 27%. Think about that. Now, thinking about these numbers, again, if you have a 250 home portfolio, 175 of those are going to have pets or animals. 175. And then dial that number in terms, dial it in terms of assistance animals. Same 250 is kind of the number I always work with, portfolio size. You're going to have at least 16 of those homes with assistance animals. And we have found, and I'll share with you on the next slide, quite a number of these are not going to make it across the line, these being assistance animal accommodation requests. But if you don't know how to work through this assistance animal accommodation request process, instead of having 16 in your 250 home portfolio, you're going to have more than 40 based upon the numbers and the percentages of what we receive versus what we recommend here at Pet Screening. So let's look at those numbers. Between 1995 and 2015, 20-year time span, over 65,000 emotional support animals were requested. But in a 5-year time span, from 2015 to 19, actually 4 years, 4 to 5, depending on how you calculate that, that number increased by 200%. 200%. And we here at Pet Screening have been processing those for 5 years now, 175,000 or better assistance animal accommodation requests. And we have found 40% of them are not meeting our guidelines and not being recommended by us as assistance animals, because that's the result we deliver to our clients. Either we recommend or do not recommend an assistance animal designation. So 60%, more than half, are not with us making it across the line. So again, what happens every time one of those either disingenuous requests or incorrect requests, it's really a pet, but it comes in as an assistance animal. Each time one of those gets just popped into your files and accepted, you are producing less income for that rental and for yourselves. Now let's take just 2 slides and talk about the fair housing background, just in case, as we said, we've got some new folks on the call with us. So obviously we had legislation in the 19th century, but we're going to start with the 20th century today. In 1964, Lyndon Johnson signed the landmark Civil Rights Act. It was a landmark act, but it was also then expanded even better in 1968. And when it was expanded in 1968, it included Title VIII of the Civil Rights Act, which became known as the Fair Housing Act. And that gave us 5 federally protected classes and touched on the civil rights as regards to housing in our country. That act was expanded again in 1988 by the Fair Housing Amendments Act, and 2 more protected classes were added. Taken in combination, the Fair Housing Act protects people from discrimination when they are renting or buying a home, when they're getting a mortgage or seeking housing assistance of any other kind. And again, now you have 7 protected classes. And I like to help folks remember these by saying, if you follow me down the slide, residents can now really sue for discrimination. Residents can now really sue for discrimination. And this covers most housing. There's a few narrow exceptions. Folks usually like to hear that, so I'll share that with you now. And again, these are very limited circumstances. The Act exempts owners of quadplexes when they live in that quadplex and only have 3 other rentals there in the quadplex with them. Single family houses sold or rented by the owner without the use of any of us professionals. And housing operated by religious organizations or clubs where the occupancy is limited to club members. So those are your only exceptions. And again, that one where the single family houses are sold or rented by the owners has to be without the use of a professional, right? Now, let's talk a little bit more in context for our presentation today about the what, the who, and the why. So the Fair Housing Act, the what, makes it unlawful for a housing provider to refuse to make a reasonable accommodation for the disabled. So for a person, that's the who. With a disability, that's the why. Again, you've got the what, the Fair Housing Act, the who, the individuals making the request. Why? Because of their disability and their need to have an accommodation to help them equally use and enjoy their housing. So if you think about the folks who are renting from you with no disabilities, you think about the folks who are renting from you with disabilities. This is their relative levels of ability to use and enjoy the home fully. And so there's a gap right here. And so these accommodation requests physically are meant to help them bridge that gap in their ability to use and enjoy the homes. I mean, they're paying the same price, but yet their disabilities leave them unable to fully use and enjoy the home. And so these accommodations are meant to help bridge that gap. Now let's talk about the HUD notice. HUD released a notice, FHEO 2020-01, and it is in your workbook. That's the other part of the retention game when we're working with education and education sessions like this. There needs to be a link to future learning. So your workbook also serves as that link to future learning. Your FHEO 2020-01 notice from HUD, as well as the HUD fact sheet, are both in that workbook for you. And I encourage you to read those. If nothing else, you'll gain a little bit more clarity. You'll have some repetition of what we've discussed today, and you'll probably get a good night's sleep if you take it to bed with you. So HUD released this FHEO 2020-01 notice, and that 2020-01 means January of 2020. And so that means it came out right before our bandwidths got completely taken up by what? COVID. So if you're like, I don't know what she's talking about, that is just fine. This is a case of better late than never. So sit tight. We're going to go over this notice and what it did for us, because it did do a lot of things for us in this industry. First, I want to say, though, this, of course, supersedes the previous notice from 2013, which means if you're doing the math, HUD let us sit for 7 years without communication with us about how to work through this important right that folks are availing themselves of left and right routinely daily in the country. They left us for 7 years, but now we do have a notice, FHEO 2020-01. It supersedes the prior notice. It's the first notice in 7 years, and so it makes it very important. And so this notice this guidance, if you will, is intended to help us distinguish between a person with a non-obvious disability with a legitimate need versus a person without a disability who's simply trying to circumvent your pet pricing, your pet policies, or both. And again, why was this released? Because this is the most common complaint form that HUD is receiving. In their own language, quoting them, complaints of this nature are the most common type of fair housing complaint that FHEO receives at about the 60% mark. So it's super important, and I congratulate you all for taking your time today to be here. So now let's hit the assistance animal accommodations a little bit deeper on that who and the what. So who is the person, what, or why rather we said, is their disability. But how do we define that? So a disabled person, and most of my slides only give you very bare language on them because I want you taking those notes. But these two slides, this one and the next one, have a good chunk for you because we don't want you to miss, we here at Pet Screening and I especially don't want you to miss these definitions and get really accurate about these 2 points. A disabled individual is someone with a mental or physical impairment that substantially limits one or more major life function, or they're on record or regarded as being disabled. We'll cover that. And for the purposes of this conversation today, are requesting a reasonable accommodation. But again, their definition, physical or mental impairment that substantially limits one or more major life activity. But what is a reasonable? And of course, they're requesting a reasonable accommodation. What is a reasonable accommodation? And if you ask 10 HUD offices, you probably get 4 or 5 different definitions, but let's see what we can do to help you with that today. An accommodation is a change, exception, or adjustment to a rule, policy, or practice that you're willing to set aside, for the requester. My apologies for that noise. I did put my phone on silent and then I turned it back on for just a moment. But again, a reasonable accommodation is a change, exception, or adjustment to rule, policy, or practice that we're willing to set aside, and therein lie the accommodation. The fact that you're willing to set aside rules, policies, or practices for the disabled requester. Please know that this includes if you have any communities that you manage, any public or common use spaces in those communities. And of course, this we know goes to the root of what we do, ensuring our customers can use and enjoy our homes as a non-disabled person would. Specific to that today, we're going to be going over reasonable accommodation requests for assistance animals. And you'll hear the word reasonable a lot. Let me tell you what HUD has outlined as not being reasonable when it comes to any type of accommodation requests, not just the ones that we're talking about today. One, a request that creates an undue financial burden. That's usually relevant to the 504 communities that have a 504 component, a type of federal subsidy. This could cover your homes if you're taking vouchers, right? So you could be subject to 504. That's something to take up internally yourselves, but that undue financial burden is usually a discussion of the Rehabilitation Act of 1973. Number 2, though, fundamentally alters your operation. That's going to be a more common factor for those of us on the call. They said, I'm disabled, I want to move in with a dog, but I need your team to walk that dog for me every day because I'm disabled. It would fundamentally alter your operations, right? This last one, though, this third, really will apply to us if the accommodation request poses a direct threat. That could really apply to our conversation today, and we'll get into that topic. All right, so I like to teach and facilitate information in chunks of 2s or 3s because I think it helps folks with their retention. So I want to talk about the language in this FHEO 2020-01 notice here for just a second. And if you'll think about holding an umbrella and the overarching language that they gave us, HUD gave us in this notice is assistance animals. And then you have 2 types of assistance animals under this umbrella. You have service animals and support animals. Most of us are dealing with 2 types of legislation, ADA and or FHA. Of course, FHA is the focus of our conversation. but ADA applies to common public use areas within a community, those open to the public. So again, if anyone is actually managing communities with pools or offices, that which is open to the public, usually just the offices, is covered under ADA, and your regulatory partner in that is DOJ. For the FHA, Fair Housing Act, Fair Housing Amendments Act, your partner is, of course, HUD. So again, as we move forward, remember that language for me. The umbrella is assistance animals, and underneath it's service and support. Now let's talk about the HUD part. So I mentioned this FHEO 2020-01 notice earlier on in the discussion a couple of times. We're going to dive into it for the next 3 slides. These are some really great points for you to be making notes of, okay? First of all, when I said they gave us this language, assistance animals, service and support, now let's differentiate between those. So we're all in South Carolina. We're not in California where they expand upon this. So a service animal here is a dog trained for a task for the disabled. That's it. So we're training in 3s. A dog trained for a task for the disabled. Anything other than that, whether it's trained or untrained, or providing those words you're used to hearing, therapeutic emotional support, that's that language you hear all the time, emotional support animals, then they're going to be pushed over to the support side. So if somebody says, I have a service pig. Nope, here in South Carolina, we're going to pop that over to the support side and have that discussion on that side of the conversation. And it's important what side of the conversation we're talking on, because the service animal side versus the support side has 2 different pathways. And the service side is a real narrow pathway where you don't get to do very much except ask a couple of questions and move on. The support side is where you really get the opportunity to really consider more fully the request. And so if it's not truly a service animal, a dog trained for a task for the disabled, we want to be talking about it on this side, okay? And by contrast, pets are not a protected class. We can deny them entry into our homes or communities, and we can charge them pet deposits, pet fees, and pet rents. But let's talk just for a second before we move on about how this notice was formed. It has a really unique construct to it. It is in 2 parts. And the first part is intended for us, for housing providers, to help us assess the requests we receive for accommodations, for reasonable accommodations for the disabled. And then the second part is for the requesters themselves, intended to be given to them or for them to understand, for them to maybe provide to their healthcare providers so that they understand what information should be included in the documentation for a support animal. And assistance animals in housing, as we said, are service or support. And please know when we're talking about disabilities, the disabilities can be physical, sensory, psychiatric, intellectual, or other mental disabilities. And the work or task has to be directly related to the disability itself. And that is in that assistance animal notice, of course. So we have service animals and support animals under the overarching topic of assistance animals. And again, service animal, dog trained for a task for the disabled. The next thing that HUD did really well for us in this notice was they provided clarity about unique animals, because we get all sorts of animal requests in the rental housing industry, and those managing individual rental homes are going to get some of the most unique requests of rental housing providers in the country. So let's talk about this for a moment. Meanwhile, I want to check in with Tiara though. Tiara, are we doing good? Did we have any questions you wanted to put out there?
Yes, I was just about to ask, we had one question. Do these rules and regulations apply to Airbnbs or vacation rentals as they apply to our short-term rentals that we normally think of, or year-to-year leases? Would these same accommodations apply if, say, someone was going to an Airbnb for a week or so?
So I've been in discussion with folks about that right now. My experience has been that those are public accommodations and subject to ADA. And not yet subject to Fair Housing Amendments Act. But I encourage you, because I think that's going to be a changing discussion, and I think folks are going to have differing opinions. And I think it's likely going to be related to the length of time someone is staying. And with Airbnb now having 1, 2, 3 month spans, when do we cross the line from public accommodation to housing? Tiara, would you agree?
Yeah, I would agree. I think that Airbnb is a new and emerging form. When the laws were written, the fair housing laws, the property rental, landlord tenant acts, we weren't really accounting for what Airbnb has become and what it will continue to become. So I think that's something that we have to be on the lookout. We have to be innovative and be ready to when it is time to pick a side on where we want to be with that, it'll be something that needs to be looked into further.
Yeah, I think that would be an interesting conversation that maybe SCR could begin to explore with the HUD office and just kind of say, are you getting any internal clarification on this yet that you'd care to share with us and or our members? And I would love to hear that.
I would agree. I'm going to do some reaching out to them and our state, the Human Affairs Commission in our state, who we do some partnerships with, so that we can provide you members and Brenda with more information about this going forward.
Absolutely. I think we're just sort of waiting to when that clock crosses the mark, I think, y'all, and I think they're going to be on the outlook for it. All right. So this notice provided us a great opportunity to finally deal with these unique animal requests. Anybody out there had piggy requests before or miniature pony requests? This is where we got the language to help us. So this notice helps distinguish the difference between household animals and unique animals. And so this is a good spot to take some notes. The household animals, HUD tells us, include dogs, cats, birds, rabbits, hamsters, gerbils, other rodents, fish, and the only reptile to make the cut, turtles. So if you're taking notes, which is the best way to make sure you retain these details and have this to look back at in the future, dogs, cats, birds, rabbits, hamsters, gerbils, other rodents, fish, and turtles are your domesticated animals. And then, of course, it's HUD and it's the government. So they have this little line at the bottom, and other animals traditionally kept in home for pleasure, just in case they forgot one, right? But those 9 are specifically delineated. Aside from that, other reptiles, not the turtles, and other barnyard animals, and animals even such as a monkey, are unique animals that you might receive a request for. And the good news is that HUD has said these are not domesticated animals, they're not household pets, and they created in this notice a burden for the requester to meet, if not 3 levels for them to meet. So let's take note of these. The substantial burden is for them to demonstrate they have allergies preventing their use of domesticated animals. That without this particular unique animal that they're requesting, the symptoms associated with their disability would substantially increase. And if it is of the barnyard variety, and this is why I think those on this call with single family homes are going to be the folks who are going to become, if you're not already, the housing of choice for those with unique animals, they have to be applying to live in housing that includes a fenced-in yard if it's of the barnyard variety that they're going to retain that unique animal in. So again, those 3 levels up that they have raised this are, they have allergies preventing the use of a domesticated animal, and this should all be documented in their letter from their healthcare provider. So they have allergies, that without the other animal, the symptoms associated with their disability would substantially increase. And then if it is of the barnyard variety, they have to be applying to live in housing with that includes fenced-in space for them to keep that barnyard animal. Question, Tiara?
Yes. So with the different type of animals, how does this work when insurance companies have specific breed restrictions? A big one that we've got a question from Matthew, and also that we get on our legal hotline is, let's say it is a verified emotional support animal. That evidence is presented to that landlord, or in our case, the property manager, realtor, and it's a pit bull or a restrictive breed that the insurance company will not insure. So it becomes a problem on that end. Have you guys looked into that any?
Well, actually, HUD has looked into that a lot, and I'm going to draw everyone's attention to Tiara. This is a great question, and I get it so often. I've covered it in the workbook. There is a memo from HUD, and that memo is dated 2006. So I say this tongue in cheek, and I'm not picking, but do you think HUD's done answering that question? The memo came out in 2006. They're done, y'all. They do not want to hear as an excuse that you have insurance that precludes a German Shepherd, a Pit Bull, a Rottweiler, any particular animal from living in the home and being someone's service or support animal. That will not defend you against HUD or South Carolina Human Affairs. You will not be able to use that successfully as a defense. Read the memo. It is in your workbook. And they're literally going so far as to saying, if you try that, you have to show us that you've gone out to market and there is no other provider out there that you can get insurance from, who does not try to require you to violate the federal civil rights of your renters, right? And that, if that is the case, it essentially kind of telegraphs they'd be willing to sue your insurance company. I mean, they're really over this particular reasoning. So please don't let that become part of this. If you have to go out and procure different insurance where they understand they can't create insurance laws that take away or limit the civil rights of the disabled, then do so.
Yes, thank you for answering that. Insurance companies like realtors, like property management companies, like landlords, all of that are all under the federal fair housing laws. So not only are you not allowed to do that, the insurance company is not allowed to either. If they're having those type of restrictions, that can become a bigger issue. But it comes down to there is an insurance, maybe not that particular company, or maybe your rates or premiums will go up for different type of animals, but that's still not an excuse to limit someone's ability with a verified emotional support animal or service animal from being able to have it in the home.
Absolutely. Thank you for that, Tara. All right. The other item on this slide that I thought was very helpful, because I routinely received multiple animal requests when I was doing this for the portfolios I supervised, 3 emotional support dogs, 3 emotional support cats. So HUD in this FHEO 2020-01 notice has said that you're allowed to individually assess each animal for their relationship, their nexus to the disability, and that each one of these 3 emotional support cats, for instance, must be delineated in the healthcare provider information as to what type of benefit they provide that is unique from the other 2. So each of these emotional support cats, for instance, would have to have in it from that healthcare provider listing out each one and what it does that is different from the other one. So multiple animal requests for, I have 3 emotional support cats. Unless you think 3 is unreasonable, you have nowhere to go. It's different now. It's not just by the number. You do get to assess them individually for the benefit they are bringing to the disabled individual. What symptoms are they helping to ameliorate by their presence? And each one has to be ameliorating a different symptom. Okay, so that's a wonderful opportunity for us as well. And on the next slide, I've got another yay for you, and then I've got 2 cautions for you. So the yay is that HUD has said in this notice that internet documents, including certificates, registrations, and licensing documents for the assistance animals themselves, that little driver's license looking thing that they show you, or the certificate with the little gold seal in the corner, or a combination of those plus the vest, all of those things that are exclusive just to the animal, HUD has said that those are not sufficient they're not independently sufficient to establish that an individual has a non-observable disability or disability-related need for that animal. It only tells you about the animal. It doesn't touch on the components, which we're going to talk about here in the next few slides, but it doesn't really talk about the components at all. In fact, I think I'd actually use the language in the fact sheet that those are not worth the money people are paying for them. So that is a great big yay for us. Now, 2 cautions. Around the country, we have had HUD complaints conciliated. One conciliation produced a document that many of us seized onto because it was part of a HUD conciliation. So it's a HUD approved document. And that document speaks to truth and accuracy. It's for the healthcare providers, and up to and including penalty of perjury for those who are signing those documents, right? And so a lot of us are using those. And HUD will tell you that's fine, provided that you require truth and accuracy in the underlying business transaction for everyone. So in essence, physically, what that means, if you are sharing a document like that to help the disabled have some form of documentation, if they say, when you ask them, what type of documentation would you like to provide in support of your request? And they say, well, I don't really have any, or it's packed up. Do you have anything to help me with? And you offer them your form and it has that language in there. You can do that provided you have that requirement of everyone engaging in transactions with you. Physically, then that means you're going to have to prove it. That's generally the modus operandi with HUD. So look to your applications, look to your leasing documents. If you're giving out a document at all to the disabled to help them through this process when they request it from you, and it includes that, you're going to need something along those lines in the application and or your lease documentation to prove that you do require truth and accuracy from everyone. You're not just raising the bar for the disabled, because that's not something you ever want to be seen as doing. Lastly, the other caution HUD has said these guidelines are not retroactive. So if you saw that a snake was no longer a traditional emotional support animal, domesticated animal, and it's a unique animal if it's being approved as an emotional support animal now, you can't go back and apply the raised bar guidelines that I gave you earlier, because again, these are not retroactive. You can do it moving forward though. All right, let's talk about the request journey, the pathways and the components. So with reasonable accommodation requests, there are two components to consider: whether there's a disability and what the connection is, the nexus between the disability and the request. So let's talk about that as well as the pathways. So assistance animals, service and support, two different pathways. This first one, don't throw anything at your own screen because you're mad at me when I say this, if you're unaware of this. This is a really narrow pathway. We get to ask them only two questions, document the answers to the two questions, and move on if the answers are correct. We are not asking for paperwork. We are not asking for training certificates. Per the HUD notice, the FHE 2020-01, no documentation. Think purpose over presence for these animals. And you're going to be able to ask, is the animal required because of a disability? What work or task has the animal been trained to perform? And of course, in this case, what work or task has the dog been trained to perform? And if they say, yes, it's required for a disability, my dog alerts me prior to an insulin imbalance, prior to an epileptic seizure. My dog wakes me in the night because I suffer from PTSD and I have night terrors. And my dog has been trained to awaken me in the night so they don't go on too long and disturb my mental well-being. Those are going to be the type of answers you are looking for. And when you get them, you're going to document those answers and you're going to move on. You're not going to say, I need a certificate that shows the training. If this is a dog trained for a task for the disabled, I want your disability documentation and your training documentation. You cannot say that. So please be very clear on that. This is a super narrow path. You probably won't have more than a handful or two of these in your entire career. This is a very limited portion of that 9% of the overall pets and animals in our country that are actually assistance animals. Of the 9% that are assistance animals, this is less than 10% of those. So it's a super, super seldom thing that you're going to see. But when you see it, obviously they want you to treat it with a great deal of sincerity and move forward. So now that we're clear on that, let's go to the wider of the two pathways, the support side. This is where proof is required, but in neither case are we looking for training certificates of any kind. Just want to make that clear. On this side, again, we're going to be asking, of course, is the animal for a known or documented or visibly obvious disability? And is it one that does work, performs tasks, or provides therapeutic emotional support? And is it a domesticated animal or a unique animal? Because that alters your pathway as well, right? Let's talk about those components. There are two parts: disability and the connection. Now let's talk about the disability part. We are not always, and I think we touched on this earlier, we're not always looking for the documentation to tell us the individual is disabled, right? We are not looking for that in the documentation if it's observable, like the graphic you see here on the screen. That individual is clearly disabled. You don't need anything from anyone else to tell you that. So too, would that be the case if someone came in with a walker, a walking stick, and the dark glasses, legally deaf, and you can tell in your communications with them, it's observable. You know that their disability is there and present. So you're not looking for it in the request itself. Also, if they're known or regarded or on record as being disabled, that means, are they receiving, in practice, are they receiving disability income or disability benefits? If they are, they're already known and regarded and on record as being disabled. Another organization is paying them or providing them with disability income or benefits. In either case, known, regarded, on record, or visually confirming it, you're not then looking for that in the documentation because those boxes have already been checked in other ways. If that's not the case, then you are looking for it in the documentation. And HUD has said you have a right to reliable documentation from a healthcare provider that indicates personal knowledge of the requester and that they have a disability. And to the next component, that there is a nexus or a connection between the request and the disability, a clear relationship between the two. They don't necessarily have to explain it, but the healthcare provider in their documentation should say that it is related to their disability. And that is part two. And again, all of this comes back to the opportunity, according to HUD, to help us help our applicants and our residents by accommodating them. And HUD has said I'm going to quote them in this because it's really important, the accommodation must be necessary to facilitate a disabled individual's ability to function. So when you receive communication and education on this prior to activation on this, you get an opportunity to understand this process and to trust the process. And as a result, to be completely graceful in your communications with those coming to you with these requests. But you never want to telegraph that you're suspicious of these requests. That's the fastest way to a HUD complaint, right? And there are so many disabilities that you cannot see. I know we want to stop and just take a moment and just kind of pause on that and make sure that we're approaching this discussion from that point. And trust the process to weed out the 60% that are either incorrect or even disingenuous, right? The communication, the education you're receiving today, and that you'll find supported for you in that workbook should be what you're putting your trust in, and being able to therefore be really confident and graceful when you're communicating with the public. I also want to say that HUD went on to say, and I think this is so touching and important, the concept of necessity requires a minimum. The showing that the desired accommodation will affirmatively enhance a disabled person's, 3 words, quality of life. It gives me goosebumps knowing that we can not only help people find their home and their aha at the end of the day, but also to improve the quality of their life. Mind you now, I reminded you all earlier, shared with you all earlier, I managed property. I came into the industry as an 18-year-old leasing agent, managed subsidized communities, conventional communities, mobile home communities, and HOAs just for fun. So I understand that we get a lot of these requests, especially here at Pet Screening. I see it every day, that are disingenuous or just unclear and not accurate. But the opportunity to facilitate a disabled individual's ability to function and to affirmatively enhance their quality of life are very serious responsibilities, and our housing provider and regulatory partners want us to treat it as such. And I think it's a wonderful opportunity for us to be graceful. Tiara, we got a question on this?
Yes, we have a question. What about when the letter is coming from online doctors? Because I know HUD has said there's specific websites, and we get this question on the legal hotline. And it's kind of, we can't, we often can't give like a for sure answer. Like every time someone comes with the online note, that means it may not be legitimate, because now, especially after COVID, we've seen that at my doctor's office, they're allowed to be seen online. It's a legitimate hospital doctor's office. So it's often situational, and it's no for sure answer for every situation. And, it kind of depends, because there are doctors who offer legitimate licensed services now online.
Absolutely. So our industry, we are, we're trying to stand up for our owners and our investors. We're trying to do our work well. I totally get this, but we know telemedicine is here to stay. South Carolina has a telemedicine law. Most states probably have a telemedicine law at this point in time, especially given COVID. I know my daughter was seen on a telemedicine appointment. I'm sure there's thousands of senior citizens in South Carolina who routinely are being seen on telemedicine visits, so they don't go to the doctor and sit in a waiting room with a bunch of other unhealthy folks, right? Telemedicine is here to stay. Because the interaction took place over something like we have communicated today does not invalidate that time spent with that healthcare provider. Any more so than if Tiara saw me on the street. Tiara knows me. She would say, "Hey, Victoria," and I would say, "Hey, Tiara," right? We know each other. Tiara, we've spoken a couple of times now on Zoom, but you know me, right? So, right, I have friends across the country, who I've not met in person. I've only spoken to on Zoom in the delivery of my education sessions, right? We know we can have personal knowledge of another human in this fashion. So the mere fact that their healthcare provider is from another state and or provided their counseling through this type of medium, or even just a telephone call, does not invalidate it. Please know that. HUD has given us a lot to work with by telling us that we can require in the documentation an indicia, as attorneys like Tiara like to call it, an indicia or an indication of personal knowledge, right? So we have that to work with, but you can't invalidate those all just because of the medium. telephone or Zoom or Teams or whatnot, of which the care was delivered and the experience took place. So please be clear on that. I know it can be a little frustrating, but it doesn't invalidate that any more so than it did for you or your own family members or friends who have had telemedicine appointments in the past 2 years.
Yes, exactly. And we have another question. Does the healthcare provider have to be certified? And I would definitely say yes, but is there any room around them being a certified licensed healthcare provider?
Well, I don't know that HUD uses the terminology licensed. So healthcare provider, I just encourage you to be careful with that and make that judgment call for yourself. Anytime you add a layer that I don't think HUD has said, I don't think they have said a licensed, licensed clinical provider. So I know that they have talked in terms of healthcare provider in years past. It could even be a pastor, right? Nowadays, we are talking healthcare provider, but I'd be careful to layer on top of that. Here in South Carolina, I love it when we get letters because you can see the license number oftentimes, and you can get on LLR and you can look up that licensee and confirm that that person is a licensee and confirm that the numbers match. But I don't know that HUD has actually said they must be licensed. So I would just exercise a little bit of caution on that. But normally that's what we're seeing in the documentation.
Okay.
All right, let's talk about these request journeys, the process and the outcome, unless you had another question, Tiara.
What if you only own one rental? Are you obligated to follow these laws? If you're a realtor, which I'm assuming all of you are for the webinar today, then you have to follow the laws, but there are exceptions and
Yeah, you're a professional. If it's your own home, you're not going to be able to say, well, I didn't use an outside professional, but wait, you are the professional. They're going to chuckle at you and they're going to slap you.
Yeah, exactly. Okay, thank you.
All right, so with reasonable accommodation requests, again, we know there are two components to consider: whether there's a disability and the connection, that nexus between the disability and the requests. We've covered that. Now let's focus on the next phase of the process and the potential outcomes. How do we move through these? Okay, I get it, but what do we actually do with them? So the request process includes a number of different things, one of which is the first place we start. We have a duty under law to consider all requests that come in, and they don't have to use these exact words, but as reasonable accommodations for the disabled. If they say they have a request for 3 service piggies and they're disabled, you have to consider the request. Now, you know what your response is going to be because we've talked about that. Here in South Carolina, do we have service piggies? No, we don't. But you have to consider the request. And strategically, it's wise of you to consider the request. Not only is it required, but it's wise of you because it gives you the opportunity to engage in what? An interactive process. HUD loves these words. South Carolina Human Affairs, in my personal experience, loves these words. An interactive process is a good faith dialogue between you and your requester. So if someone comes to you and wants to make a reasonable accommodation request for the disabled, great. It is my duty under the law to consider all requests for reasonable accommodations. Let's get started with an interactive process, you and I. And that means you and I are going to have a good faith dialogue about your reasonable accommodation request. And I have required paperwork for you to fill out now. No, that part at the end is the wrong answer. I'm glad to consider your request. It's my responsibility. We're going to engage in an interactive process. And what paperwork or documentation do you have that you would like to submit to me in support of your request for this reasonable accommodation? We cannot require our own paperwork, right? Nor can we ask about the disabilities or the specifics of the disability or disabilities. So let's say they have provided you with documentation in support of their request. You've got this paperwork in hand. What does HUD say in this notice that you're supposed to do? Well, one thing they tell you is a best practice is that you should have an answer back to this requester within 10 days. Now, I'm going to challenge HUD on this one and say it's not a best practice. They're giving you a timeline. And they're giving you, if not a timeline, a deadline, because they're telling you on the 11th day the requester can act as though you have denied their request if you've not provided them with an answer. A non-answer within a 10-day time frame on the 11th day can be counted as a denial. So is that a best practice or a deadline? I'm going to call that a deadline, and you should too, okay? But what's next after that? Let's see. Forward, approve, deny, or do you have other options? So I'm going to have to put this question back on you all for a moment. in your construct where you are, now I know realtors are independent contractors, but if you're part of an organization, what is the standard operating procedure in your organization? Are you supposed to gather all this information and then upload it to somebody else in your structure, your risk management, your legal counsel, or are you where the buck stops in this discussion? If you're where the buck stops in this discussion, let's talk about what you're supposed to do next. You're supposed to work through what we've talked about in our time together today. Is a disability obvious? Are they known or regarded on record as being disabled? Or is the disability confirmed in the paperwork? In the paperwork, does it also tell you that there's a nexus, a connection between the request and the disability? And does the request appear reasonable on its face? Is it for 12 emotional support cats and all 12 of them have a different delineated purpose and benefit and ameliorate a different symptom? Even if it's in there, is that really reasonable? All right, so what are your options? You can approve it, you can reject it, or a combination of the two. Let's talk about that. So if the request is going to be denied, specifically, you have to be able to say to yourself, why is it being denied? And you should have this documented in your paperwork for when, not if, when you are challenged on one of these. And again, you will be talking to HUD or South Carolina Human Affairs. So, and South Carolina Human Affairs, by the way, is very sensitive to, if not absolutely unwelcoming, to you all contacting the healthcare providers to authenticate the documentation like we do at pet screening. I believe if my suspicions are correct, they found too many people contacting healthcare providers, challenging the veracity of the relationship and trying to dig into the details of the disability. And they're really not wanting you all to do that in the future. So if you do engage in that, you do need to know that, and you do need to document very carefully that you're doing that. I do want to give you that as a footnote. But if we're here at the point where we're thinking about denial, why would we? Well, if you can't visually confirm, they're not known, regarded on record as being disabled, and the documentation doesn't tell you that they're disabled or provide to you a diagnosis that you can look up and confirm is a physical or mental impairment that substantially limits one or more major life functions, you've not checked the whole foundation of this. You're being asked with a reasonable accommodation for the disabled to set aside your rules, policies, or practices. That's an accommodation for the disabled. But if they're not disabled and you're not able to confirm they're disabled, the whole thing falls apart right there. All right, so what if they are disabled, but the request has no relationship to their disability, or the request is actually not touched on in the documentation, only the fact that they're disabled is? Well, again, there has to be a direct connection between their request and their disability. What if the individual came in with their emotional support animal or their service animal, up walks another person or animal, and they can barely control the animal's aggression, barely controlling it, taking all their physical strength to control that animal? That's not reasonable. That animal, and that was the third thing in our definition of what's unreasonable, that HUD says that you can deny one of these for, because it presents a direct threat. So if you have visually confirmed, that there is an aggression issue, the animal presents a direct threat, and that could be something that you're denying it for. At that point, though, if you were able to confirm the disability visually on record or in the documentation, should you just out of hand deny it? I think no. I think a better way to go is to say for the confirmed disabled that you're unable to approve this particular accommodation request, but you would love to continue the interactive process to see if there's another animal that doesn't pose a direct threat, or another accommodation that clearly their healthcare provider can say is directly related to their disability, so that you can accommodate them in the future. I kind of like that middle phase and letting them know that you want to continue that interactive process. But this particular request cannot be approved, but you want to continue the interactive process and consider another request to help them ameliorate one or more of the symptoms associated with their disability. And I think that you'll find South Carolina Human Affairs, that will resonate with them incredibly. I've had a number of interactions with them, and I think you'll find that that resonates incredibly so. This particular slide, if you haven't printed out your workbook yet, is really important for you to note. So please make sure that you're going back to this one and reading through this again, okay? Now, if the request is being approved, that still leaves you with some considerations and things that you have to think about. Do not treat this animal as a pet. As a matter of fact, as you want to question yourself as to what you should or shouldn't do in the future about these assistance animals, I want you, every time you think through the question in your mind, to use the word wheelchair or walker instead of pet. What would you do about your rules, your policies, your practices as far as their walker or wheelchair. And that will help you arrive at your own answers to your own future questions. But for our purposes today, don't treat it as a pet. Don't charge it any pet-related fees or deposits whatsoever. Please don't have them sign any pet documentation. Even if you cross out any of the monies that are normally owed, I wouldn't have them sign a document with the word pet in it for all the T out there at all, because it only will help afford them the opportunity to prove an assertion that you're treating their assistance animal as a pet if you have them sign a documentation with the pet language in there. So if you have a pet addendum that you want to use for this purposes, take out all the language about pet fees, rents, or deposits, Control F that document, find all the words pets, change that to assistance animals so it covers service or support, and then double check it again to make certain that you're only talking about those animals in the same terms as you do pets, as far as how they're supposed to control them and how they're going to be responsible for any damages and for keeping up the cleanliness and sanitation, such as picking up pet waste, right? So you're talking about the behaviorals only. And then try to receive, retain, and track these records as you do for pets. If you require vaccination records of pets, require it for assistance animals, and receive, retain, and track all that. And please secure the documentation about the disability request itself from the healthcare provider, especially well. We here at Pet Screening kind of consider that HIPAA level type of things. And we have some HIPAA compliancy mapping in our data storage that we have here, because there's just so much, that you need to do with regard to that as far as respecting their privacy, and everybody in your office is just not reviewing that for no good business valid purpose. And here I want to say that there's a lot of monetary settlements out there, a lot of complaints out there, a lot of lawsuits out there, but the numbers on this screen don't begin to touch the true damage to your time and treasure, because it doesn't account for your attorney's fees, and it doesn't account for the value of your time. And as HUD is inundated with these, this is 60% of what they receive, they're going to press that 100-day button on you several times. It's going to go on for a while. They too are inundated as your partner and trying to weed through all of this, right? So this is going to go on for a while. And the way it works, you're kind of guilty until proven innocent. So your time and treasure is valuable. Make certain that you're following good policies and practices, that you're sticking to the HUD FHEO 2020-01 notice. Make sure you're pulling language directly from it when you're communicating and writing with your applicants, clients, prospects, or residents. Make sure that if an error occurs, it's an error. It's not a pervasive policy or practice, because that's when you actually get the really bad punitive damages, because they feel like they have to punish you, how to teach you how to do your job in compliance with the law. You don't want them to get to that punishing phase. And just to share with you a little bit again, to impress upon you about that workbook, I really would love it if you would print that, put your notes with it, put a big clip on it, and keep it handy. There's a report in there from us at Pet Screening about pet policies and amenities. There's a HUD fact sheet in there that goes with that HUD FHEO 2020-01 notice, which is also in there. And that HUD insurance memo from 2006 is in there as well. I also look at this documentation as a great conflict resolution tool. If you're in person or on the phone with somebody who's getting really upset about your declination of their assistance animal request, you can say to them, can I put you on hold for a minute? Can you have a seat and let me get you a glass of water? I want to pull my documentation regarding HUD's policies on this, because that's what I was following when I was communicating with you, doing what our regulatory partner at HUD has guided me to do. And I want to pull that guidance for you and go over it together. And I want you to help me see if there's something I'm missing that the HUD guidance has spoken to. I think of it as not only a great connection to your future learning and a place to put your notes from today, but as a good conflict resolution tool, okay? Then I want to share just a touch with you about Pet Screening, because Pet Screening affords me the opportunity to be here with you all today. Our videographer produced that shortened version of this presentation for us as well. So we put a lot of time and energy into our presentations and to helping educate everybody in the industry. I want to share with you what we do for you, though. We were created to help pet-friendly housing providers understand the risks associated with the pets they're welcoming into their rental properties, to help them generate additional pet revenues, sincere additional pet revenues, and to understand what they need to know and have a data acquisition and activation system, all for free. We don't charge you anything for our work, via our 3 household profiles, either the no pet profile, the household pet profile or the assistance animal profile. And that assistance animal profile also comes with all of the processing of the assistance animal accommodation request. So everything we've talked about today, we have an entire team of assistance animal reviewers and assistance animal authenticators and our chief and associate legal counsel sitting in Mooresville, North Carolina, doing all of this for our more than 2 million, 2.5 million rental properties around the country. And we've processed more than 175,000 of these assistance animal accommodation requests so far. Yeah, and pet screening, of course, is easy to deploy. We have integrations, both flat file and two-way API out there in the world. Of course, it's centralized and digitized. There's no contract for you to sign, and our services are absolutely free to you. We charge the pet household only out of the 3 households we serve, and we charge nothing to you. And what we charge the pet household, incredibly reasonable. It's $20 or $25 for the pet profile, depending upon the form of payment we receive. And that's the initial fee. And then it's 10 or 15 a year. And for that, you're getting an amazing liability control system, a pet revenue enhancement system, a data acquisition and data activation system. And again, all of this assistance animal processing done for you. And it's all easily trackable, everything date and time stamped. And you've got a great team of professionals doing it for you. So thank you, Tiara, for letting me be here today to speak to my fellow members of the Association of Realtors. As a CPM, I am a realtor with you all as well, and I appreciate being here with everyone.
Thank you so much. Let me make sure we don't have any questions. We had a question in some municipalities. Sorry, I couldn't get it out.
That's a tough one.
Yeah, it was. Have restrictions on breeds. What is the process in that situation? Well, municipalities are also under fair housing laws, so they would be in violation.
If they erroneously pass legislation, ordinances like that, then that's on them. You abide by the federal civil rights that have been afforded to all of your clients, applicants, customers, whatever terminology you want to use. You abide by that. If the city wants to say that there's a pit bull in that house and they want to bring you to task, you hand them the FHEO 2020-01 notice out of your workbook and tell them to go packing. That is on them entirely. You have to abide by the civil rights of these folks. You cannot say that that municipality instructed you to take away their federal civil rights.
Yes, I would agree. And we have, what were the exemptions? Probably, I'm not.
Yeah, well, I'll go back to those. But you know what? I want to touch on something just one more time because I want to make this super clear. And this is a sensitive way to say this. So please take me at my graceful, loving self that hopefully you've seen me to be. I want you, when you think of somebody, a municipality, an insurance company, if they say to you that you're not allowed to welcome in this animal that is truly someone's service or support animal, and they say because it is a restricted breed, I want you to say, instead of Rottweiler, I want you to say Muslim, Christian, Chinese person, Middle Easterner. If they told you not to rent to one of those people because that was their policy, would you follow it? And the answer is you absolutely would not. We're all graceful, intelligent, loving, decent adults, and you would absolutely not. And I express it to you that way just because it really makes it painfully, awkwardly clear that we would absolutely never allow a municipality to take away someone's civil rights based upon their race, their color, their religion, their national origin. We would never do that. Never, never, never would we do that. And so that, I think, makes it clear moving forward. So if anyone tries to tell you that you have to take away some of these disability rights for assistance animal accommodations, double check yourself with one of the other protected classes, and it makes it very, very clear. Yes. So with the exceptions, does that work for you, Tiara? Does that pass muster?
That's great.
All right. So with regard to the exceptions, if an owner lives in a quadplex and they're living in one and they have 3 rentals, they don't necessarily have to follow these regulations. If somebody has a home that they're renting, I think it's less than 3 homes, and that they're renting or selling, and they're not using a professional to do it, and they themselves ought not to be a professional either, there is an exemption for that. And then if residency in this rental property is limited to particular members of a club or particular religious group, I think they too are exempted. I would be super careful to ever try to and double and triple and quadruple check myself, though, before making use of any one of those exemptions.
All right. Thank you so much for joining us today, Victoria. And in the interest of everyone's time, if you guys have follow-up questions, of course, you can reach. Will we be able to obtain these slides for distribution to the attendees today?
They're in the workbook. That's a great question.
Wonderful.
Each of these slides is in the workbook. So the workbook is comprised of this entire presentation and all your support materials. So you've got that link to future learning. So a week or 3 days from now, go and look at that HUD fact sheet. A week or so later, read the HUD notice again. And then you're going to be locked and loaded, and you're going to be just so ready for these questions and so easily able to answer them.
Yes, well, thank you so much again. I'm sure we're going to be doing more in the future together. And you guys have the workbook. If you didn't receive the workbook, you can also reach out to us so that we can make sure that you get that. It was sent out with your registration. And I hope you all have a great rest of your afternoon.
And if you go to the upper part of the chat, not the first link, but the second link in your chat before you jump off, hop into chat and copy that link. If you didn't get it, it is in there for you as well. I think Sharon was kind enough to put that link in there for everybody in the chat. So before you jump off, go to chat all the way up to the top, second link.
Yes.
Tiara, thank you for having me, and thank you for the opportunity to build a relationship with you all and to be here helping to serve my fellow realtors and the public, who we're entrusted with the care of.
Well, thank you so much. I hope you have a great weekend and a great rest of your afternoon.
I appreciate that. I hope everyone else does as well. Take care.
Bye.